Hey guys, Marcus Melnick here with Firearm Mentor. Hope you're enjoying my YouTube channel. Don't forget to like, share, and subscribe. These little things are free to you and really help the channel. I appreciate your support. Enjoy. Thank you.
The views expressed are not those of local community broadcasting, WYML LP, or its management, volunteers, or underwriters. Good morning and welcome to the Personal Safety Show. This is Marcus Melnick from Firearm Mentor and Stress 2 Logic, your host. And I have some good news and some bad news. The bad news is time flies. But the good news is you're the pilot. I found this inspirational quote from a coworker who now sends out inspirational quotes, and I wanted to share it with you. We've got a ton of information that we would love to share with you, and we're going to start with some exciting news. And the question is, are machine guns constitutional? Well, according to a judge, they may be. Let me tell you about this. A federal judge has declared the machine gun ban unconstitutional. In a major ruling out of the Southern District of Mississippi, Judge Carlton Reeves has struck down the federal machine gun ban as unconstitutional under the Second Amendment. The case, United States v. Brown, follows a framework established by the Supreme Court in the New York State Rifle and Pistol Association v. Bruin, which requires gun laws to be justified by historical tradition. Now, while the law has been ruled as unconstitutional, the judge openly expressed skepticism about the Bruin framework. Nevertheless, he followed the Supreme Court's ruling as written and determined that the government failed to meet its burden, proving that 922-0 is consistent with the nation's historical firearm regulations. The defendant, Justin Bryce Brown, was charged with an unlawful possession of a machine gun under 18 U.S.C. 922-0. His argument was that under Bruin, the statute is unconstitutional as applied to him. The government's response was predictable. It argued that machine guns fall under the Heller established category of dangerous and unusual weapons, which courts have long held are not protected by the Second Amendment. However, Judge Reeves rejected this argument, reasoning that while many machine guns are certainly dangerous, the government failed to prove that they are unusual. His ruling pointed to the fact that over 740,000 machine guns are legally owned in the United States today. It's a significant number that undermines the idea that they are outside the scope of common use. The most striking aspect of the judge's opinion is his acknowledgement of Bruin's limitations. He openly questioned whether the Supreme Court's historical approach is the best way to evaluate Second Amendment cases, calling it deeply concerning, and noting that it will likely lead to confusing lower court precedent. However, despite these concerns, he applied Bruin faithfully, dismissing the indictment against Brown. Although Brown follows Bruin, there is ample language in the Supreme Court decisions, both before and after Bruin, that suggest machine guns did not receive Second Amendment protection. In the District of Columbia v. Heller, the Supreme Court reaffirmed that the long-standing doctrine that the Second Amendment does not protect dangerous and unusual weapons. The court traced this doctrine back to English common law and applied it to modern firearms. Bruin itself contains similar language, with Justice Kavanaugh emphasizing in his concurrence that nothing in the ruling should be interpreted as questioning existing restrictions on dangerous and unusual weapons. Given these precedents, if Brown is appealed, the Supreme Court may take the opportunity to clarify whether machine guns continue to fall outside the scope of constitutional protection. But it has to get through the Fifth Court of Appeals first. About that, a key precedent in the Fifth Circuit is the issue of Hollis versus Lynch, a 2016 pre-Bruin case which explicitly held that machine guns, quote, do not receive Second Amendment protection, end quote, because they are, quote, dangerous and unusual, end quote. However, Judge Reeves directly addressed Hollis in his ruling and made two critical points. The first one is he stated that Hollis has been abrogated by Bruin, but did not engage in a deep analysis of whether the dangerous and unusual standard applies. In reality, the reality is that even if Hollis predates Bruin, the Fifth Circuit's holding that machine guns are dangerous and unusual remains relevant because that standard continues to be applied in Second Amendment cases. After all, the phrases dangerous and unusual appears 135 times in the Bruin decision, so Hollis remains relevant even as a pre-Bruin decision. The other factor is Judge Reeves highlighted a factual discrepancy in Hollis's common use analysis. When Hollis decided in 2016, the record stated that there were a little over 175,000 legally owned machine guns. In Brown, however, the record states that there are over 740,000. Judge Reeves observed that he does not understand the cause for the discrepancy, although it's been speculated that this is transferable versus non-transferable, but legally possessed machine guns, meaning post-1986 non-transferable machine guns owned by a stamp holder. However, Judge Reeves noted that the Hollis appellate decision ruling that 175,000 machine guns were uncommon does not necessarily resolve the question of whether 740,000 machine guns are uncommon. This is a crucial distinction. The Hollis court might not have called 740,000 machine guns unusual, even though it found 175,000 was too small a number. This creates an opportunity for the Fifth Circuit to reevaluate Hollis in light of new data. One of the most significant flaws in the government's argument is the circular reasoning behind the idea that machine guns are unusual. Machine guns are rare because of the federal bans enacted during the 20th century, and because they are rare, the government argues that they can be banned. And because they are banned, they remain rare. This is a circular argument. The self-reinforcing logic is not a legitimate historical or constitutional argument. It is simply a consequence of previous legislative decisions. Under the Bruin framework, laws must be justified by history and tradition, not the fact that the government has successfully restricted certain firearms subsequent to 1986, 210 years after the country was founded, and only about 4 decades subsequent to the invention of perhaps the first true fully automatic assault rifle, the STG-44. If the Second Amendment's scope is determined by historical regulations rather than modern policy preferences, the government cannot use its own bans as evidence that a firearm is outside constitutional protection. So you may ask yourself, what happens next? Well, if Brown is appealed, it'll go back to the Fifth Circuit, which is the most conservative federal appellate court in the country. That is important because while the Fifth Circuit has been aggressive in striking down gun restrictions post-Bruin, it has also previously ruled against machine gun protections. As mentioned in the Hollis v. Lynch, the court unequivocally stated that machine guns do not receive Second Amendment protection. More recently, in United States v. Simeon, a 2023 case, a federal district court, not an appellate court, in the Western District of Texas, rejected an identical Bruin-based challenge to the machine gun ban. The Simeon court held that, quote, assuming the conduct of possessing a machine gun is protected by the plain text of the Second Amendment, the weapon itself will not be protected based on the U.S. Supreme Court and Fifth Circuit precedent, end quote. The court cited Heller, Miller, and Hollis and concluded that machine guns are still not in common use. Simeon shows us that even though Hollis is pre-Bruin, courts within the Fifth Circuit are still willing to ignore the fact, and it may be correct, it may not be correct, that the dangerous and unusual standard still applies post-Bruin. The Fifth Circuit is not expected to uphold Judge Reeves' ruling in the event of appeal, but there are hopes for people that love machine guns. Since this is a criminal case, the ruling only applies to Justin Bryce Brown. It does not overturn the machine gun ban nationwide and does not mean new machine guns will suddenly become legal. However, the case has broader implications. If the ruling is appealed and upheld, it could trigger, more challenges to the National Firearms Act, or the NFA, and other federal gun restrictions, including regulations on suppressors and short-barreled rifles. Either way, the case is far from over. The Fifth Circuit and possibly the Supreme Court may eventually address the fundamental issue at play: whether machine guns can be considered dangerous and unusual when their rarity is a direct result of government restrictions. The decision is just one more step in what is shaping up to be a defining Second Amendment battle in the post-Bruin area. So let me give you my take on machine guns. I have shot them. Look, I worked in law enforcement, and you go to shooting events, you can rent machine guns. So I've shot an M4, a FNP90, and an MP5. The MP5, and it was suppressed, was my favorite by far. The recoil was almost nothing. I absolutely loved it. But the reality is, machine guns are expensive. I don't know if I would ever own one, because you go to the range. It's kind of like a ride at an amusement park or Great America. You wait and you wait and you wait, and finally you get on that roller coaster, and it's over in 2 seconds. 2 seconds. So it's the same thing with a machine gun. You load, boom, you're done in 2 seconds because the magazine empties. So for me, it's a novelty. It's not something I would ever own, especially at the current price points. And it's fun, but it's fun once or twice or once a year. It's not fun to go to the range and blow hundreds, maybe even $1,000 on ammunition just to miss the target. Machine guns require some training to utilize, and they're not always there to be effective. As a matter of fact, there's a cousin I have in the Israeli army, and they're issued machine guns. And he told me they never shoot them in 3-round burst or full auto. They shoot them in semi-auto, because they found that if they shoot in 3 burst or they shoot in full auto, they're not as accurate. Very interesting. And he's told me about some battles he's been, like legitimate battles that he's been in. So he has some combat experience. I really don't. I was not in the military, but very interesting. So let's turn some news back to home in Illinois. There's a new Illinois bill that aims to prevent repeat gun charges for first-time offenders. Now, I don't know, what does this mean? Well, Cook County State's Attorney Eileen Burke introduced a legislative proposal aimed at providing first-time, nonviolent gun offenders with an opportunity to comply with licensing regulations. This proposal seeks to allow eligible individuals to obtain a FOID card while participating in a diversion program. The initiative, which applies only to individuals charged with a Class 4 felony for gun violations, was designed to help otherwise law-abiding citizens who failed to secure a FOID card before possessing a firearm. Under Illinois law, residents must hold a valid FOID to legally own or carry firearms. Currently, the participants in the first-time weapons offense program can't apply for a FOID until after their charges are dismissed, which means many finish the program still lacking the proper license. Burke says that the proposal aligns with her office priorities of cracking down on illegal guns while ensuring fair treatment of first-time offenders. Quote, "There's no higher priority for this office than getting illegal guns and the people who use them off the street, and we will use every resource at our disposal in that effort," Burke said. She also went on to say, at the same time, we would be smart on how we use our resources and how we impact people and communities. The bill provides another tool to strike that important balance. The proposed changes were introduced in the Illinois General Assembly by State Senator L.G. Sims, who's a Democrat in Chicago, and by State Representative Justin Slaughter, who's also a Democrat in Chicago. The legislation would allow eligible participants in diversion programs to apply for a FOID card during their program participation. The Illinois State Police would still have the authority to deny applications if people do not meet legal qualifications for such gun ownership. This proposal is the first legislative initiative introduced by Burke since she took office in December. Now, the proposed legislation awaits debate in the Illinois General Assembly, where it will be considered as part of broader efforts to reform gun laws and enforcement policies in the state. There is also a court case on the FOID card. The Second Judicial Circuit Court has, for the third time, struck down the requirement of having a FOID card in the home as unconstitutional in the case of the people of the state of Illinois versus Vivian Claudine Brown. The Illinois State Rifle Association legal team is representing Ms. Brown in this nearly 8-year-long battle to recognize her rights. So what happened? Well, in 2017, Vivian Brown became fearful of her husband and separated from him. During that time, she was in possession of a single-shot .22 rifle for her protection. The estranged husband filed a complaint on Ms. Brown, alleging she fired the rifle in the home. Police responded and found the rifle had not been fired, but the state's attorney charged Vivian with possessing a firearm without a valid FOID card. According to Richard Pearson, the Illinois State Rifle Association, or ISRA, executive director, he said today, in response to this ruling and other legislation being enacted, it is the height of hypocrisy for Governor Pritzker to sign legislation today claiming to protect potential domestic violence victims, while at the same time the FOID Card Act is being used to disarm those same potential victims. Now, we're going to continue on with this story, but I'm going to talk to you about that legislation next. The FOID card is a requirement to obtain a permit to exercise Second Amendment rights in the home, and Judge Webb this week found that to be unconstitutional again. Additionally, the requirement to pay a fee to utilize that same right was also found unconstitutional as part of his ruling. Again, Richard Pearson, the executive director of ISRA, said, the state claims that they need to charge $10 as an administrative fee. The ISRA agrees with Judge Webb that the right to self-defense is just as important as the right to vote. Can you imagine if voters had to pay a $10 fee in order to vote by mail? Illinois Democrats would be up in arms about disenfranchising voters, but have no problem doing the same thing to firearm owners. Now, here's the interesting thing. I don't remember if I had to put a stamp on vote by mail, but if I did, I had to pay 50 plus cents to vote by mail. Interesting. The Illinois State Rifle Association continues to support Ms. Brown in this case, and once again, the ISRA attorneys have won. This case will be heard by the Illinois Supreme Court for the third time in 8 years, and the Illinois State Rifle Association will continue to be by Vivian's side as they continue to fight for Second Amendment rights in Illinois. You can go to their website, isra.org. That stands for Illinois State Rifle Association.org if you want more information. So, what was that law that Pritzker signed? Well, he signed, quote, Karina's Law, end quote, to remove guns from domestic violence situations. Karina Gonzalez and her 15-year-old daughter Daniela were shot and killed on July 4th in 2023 at their Chicago home, allegedly by her husband. After more than a year of negotiations, Governor Pritzker signed a bill in her honor Monday that is designed to remove guns from domestic violence situations. As I look forward to the future, I hope that future survivors won't have to suffer as much as our family and countless others have at the hand of abusers, said Manny Alvarez, Gonzalez's surviving son, at a news conference. House Bill 4144, also known as Karina's Law, clarifies that law enforcement must temporarily remove guns from a person who has an order of protection against them when the alleged victim seeks firearm removal as a remedy in court. Current law allows people asking court for an order of protection to request a, quote, firearm remedy, end quote, that would lead law enforcement removing guns from the alleged abuser's possession. Karina's law closes the loophole that made it unclear who was responsible for removing a gun in the situation. Under the law, the person who seeks an order of protection can also ask the court to issue a search warrant that would allow local law enforcement to seize firearms from the alleged abuser. The petitioner or state's attorney must demonstrate probable cause that the alleged abuser poses an immediate threat to the petitioner. Law enforcement would then be required to execute the warrant within 96 hours of it being issued. Quote, taking lethal weapons from those who have already done harm and are in immediate and present danger to do further harm is simply common sense, said Pritzker. Guns and domestic abuse are a deadly recipe, said Amanda Pyron, CEO of the Network, an advocacy group that focuses on preventing domestic violence. Between 2019 and 2023, Illinois saw a 63% increase in gun-related domestic violence deaths. Now, I always question statistics. I'm going off of an article. This article may be leaning to the left, may be leaning to the right. It is from WTTW. I don't know if they lean left or they lean right. It's always best to check the sources. An emergency order of protection is often the first step out of a violent relationship, said Pyron. It can also be the most dangerous step. This is the time that the survivor faces the most risk because it's also the time that the abusive partner realizes, and this article says that, or she said that he is losing control, not that he or she specifically focused on men. That's very interesting to me. It's an interesting little detail. Supporters of the law said they hope closing the loophole will make it safer for victims when they seek a court's intervention. Pritzker said Karina's law will protect survivors of domestic violence and give them comfort, the comfort of knowing that their abuser will not have easy access to firearms. The nation's high court upheld a federal law last June that prohibits people with domestic violence-related restraining orders from having guns. Though Karina's law had previously passed through the House last spring, senators delayed action while waiting for the decision. Don Harmon, one of the most anti-gun people, Democrat from Oak Park, said, I was relieved when the court gave us far more elbow room than I would have expected to tackle this issue, and now we have, and we've done it in a manner that is effective and constitutional. Though the bill received bipartisan support, some gun rights and Republican lawmakers expressed concerns that the bill undermines due process afforded to people accused of crimes. They argue that taking guns away from a person with an order of protection against them assumes guilt on criminal charges and violates their constitutional rights. Orders of protection are filed in civil court. This policy sends a clear message to those living through trauma and terror of domestic violence, said Representative Mara Hirschauer, Democrat of Batavia. Here in Illinois, we see you. You have the absolute right to leave your abuser, and we will do our best to keep you and your family safe. And most importantly, here in Illinois, we value your life and the lives of your families more than we value your abuser's gun. Illinois law enforcement agencies have also had concerns about their ability to carry out the law, indicating where police agencies would store the confiscated firearms and the logistics of carrying out such search warrants against alleged abusers. Law enforcement organizations and lawmakers came to an agreement over those logistics. If a victim has not made any reports of domestic violence to police within the last 3 months, police will have 48 hours to research the situation behind the order of protection and make any changes to the search warrant. Warrants then must be executed within 96 hours of these changes. The person who has an order of protection against them will also be able to petition the court to have the gun transferred to another person who can lawfully possess a firearm. Maralea Negron, Director of Policy for the network, said this is designed to help smaller sheriff's offices who do not have capacity to store guns. Now, here's my opinion on this. Should domestic abusers have guns? No. However, what happens when they're falsely accused? I don't know. That is a fear of mine. So, what do you guys think? I don't know. Write in. My electronic business card is www.marcusmelnick, that is MarcusMelnick, melnick.com. I'd love to hear your thoughts. In talking about concealed carry training and private lessons, I just made a move for Firearm Mentor, which will make things easier for those who do not carry cash. After today, it's being shipped to me. I'm getting a mobile credit card reader, which allows me to take credit cards on site. I got this credit card through Marty Adelberg. He's with EMS Midwest. His phone number is 847-529-1609. His email address is Rabbi Martin. He's also a rabbi. RABBIMARTYN @gmail.com. And his website is plusbyems.com/4140. That is plusbyems.com/4140. This is going to be a huge thing of convenience. I won't have to do Zelle or Cash App or all the other things that not everyone has the same thing, but typically everyone has a credit card or a debit card. I've worked with him over the last few weeks. I've known him for several years, but I worked with him over the last couple of weeks to implement this. Now I can also take credit cards for public speaking events. So if you are a small business or small organization that has a debit or credit card and you hire me, my website for that is www.stress2logic, that's STRESS, 2logic, LOGIC.com. I can also take credit cards through that business as well because it goes to my parent company. Stay tuned because after the break, we'll have more firearms-related news. Thank you. The views expressed are not those of local community broadcasting, WYML LP, or its management, volunteers, or underwriters.